Thanks for coming back. Every week, Wednesdays and Fridays. Today is Friday, right? And we love Fridays, because Friday is the day that we get to do civil procedure. And we like doing civil procedure because it helps us make sense of the insane and irrational world in which we live. Like this news article about a vineyard lawsuit against a pot operation. The judge rules blah, 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 blah. Look at this first paragraph. A federal judge has ruled that a vineyard has plausibly alleged harm from a neighboring marijuana operation and may proceed with a racketeering lawsuit against it. Look at that. Look what you learned in civil procedure. What are they talking about here? What was the device? What was the decision that the judge made? What was the motion made by the defense?
Motion to dismiss.
What?
12B6.
12B6. 12B6. What was the case they cited in their 12B6 motion? Iqbal, saying these allegations do not plausibly state a claim for relief. That's what they're talking about, and that's this story. Isn't that exciting? That's your money's worth for this course. Right there. Also, just an interesting tidbit about this one. The Racketeer Influence and Corrupt Organization Act. Anybody ever heard of that one before? You will. You'll run into it. Because, especially if you go into a plaintiff's practice, people will be calling you with this all the time, wanting to sue someone under it, because it's kind of one of those big catch-all federal acts. The RICO Act. RICO. I think it's in some mob movies too. Right? RICO, often used to go after mobsters and the like, but can be construed to be used in just about any sort of situation. Usually when I see RICO litigation, it's been brought by somebody who either doesn't know what they're doing or is a crazy pro se plaintiff, or both. So take those with a grain of salt. But this appears to be at least a RICO suit that can get beyond the motion to dismiss stage. So very exciting stuff. All right. For the really exciting stuff, though, we've got to discuss answers. Now, we've come this far in the course. What is this, week 3, 4, something like that? And we're finally at the stage where the defendant might have to provide some sort of substantive response to the allegations against it, okay? Think about where we are, the journey that we've been on so far. There's a complaint. The complaint was served on the defendant. Assuming service of process was proper. No problems with that. The defendant has now tried a motion to dismiss. We'll assume that that has been denied, and the court says, no, you've got to answer that complaint. Okay? That's where we are. Taking us 8 classes to get there. How do you do that? Seems kind of simple, right? Just answer it. Say, I didn't do the stuff.
No, I'm good.
Yeah, right. I don't want to get sued. Everything that guy just said is bullshit. Okay? Well, there are some landmines that you can step on answering a complaint, but not too many. It is rare. We'll talk about this more as we go along. I mean, the book gives you some horror stories for sure, but it is rare that a judge is going to torpedo a case based on some defect in the answer alone. Okay, so keep that in mind. That said, there are some things that you can royally screw up if you're really trying in your answer. Right, so let's look at Federal Rule 8B. Where did I stick it? 8B has got all the good stuff for us until we get to 8C, and 8C is even better. But all this wants you to do is to state in short and plain terms defenses to each claim asserted against the defendant, right? So the claims that are asserted against the defendant, those are the ones that have to be answered. Admit or deny the allegations asserted against. Okay? Not every allegation necessarily, just the allegations that are made against the defendant. That seems to be an important distinction in the rule, and you would think with your lawyer brain that it is an important distinction, but in practice, most of the time, not super important, because what you see is an answer that corresponds paragraph for paragraph with whatever the plaintiff filed in the complaint, okay? So you'll see that in the examples that I put up on Blackboard. Oh. So this answer from the Southern District of Indiana is matching the plaintiff's complaint paragraph for paragraph. And I think most of the ones that I put up for you are like that. But you'll see they're all kind of slightly and annoyingly different. So everything about venue is answered. Everything on the facts is answered in some way, shape, or form, right? Whether or not they have to, technically under the rules. What can you do with the allegations that are actually made against you as the defendant? Your client is the defendant. Well, you can admit them. Sure, why not? Is it ever appropriate to admit allegations against your client in an answer? Yes. Okay. Yes. You are obligated to, right? In some instances, you're likely to be obligated to admit some of the allegations that are against your client, or at least some of the allegations that are in that complaint. Because if it's a well-drafted complaint, many of the allegations are likely to be true. Right? And as you've seen from the reading, you can't deny just for the sake of denying, just because you feel like it, just because you want to be a pain in the ass, just because you want to be an aggressive, zealous advocate for your client. That doesn't mean you deny. That's not what that means. Although you can deny, right? It's not true, deny it. Simple as that. Look with me at 8B3 for this general denial language. Oh, where did it go? 8B3, if you can see it, right? A party that intends in good faith to deny all the allegations of the pleading, including the jurisdictional grounds, may do so by a general denial. Do you guys want to guess how many times I've seen that in my career?
0?
You're right before, yeah. 0. I don't remember ever seeing somebody filing something that just says, we deny everything. Everything. Every last word, every last punctuation mark, the state that it's filed in, the venue, the names of the parties, we deny it all. Right? Not a very good idea. I don't think that you're doing your client a service by doing this general denial thing, and I've never seen it. And I'll jump ahead and say, you've got to know, maybe there's some jurisdictions in America where general denials are very common. It's very common to file just a one-paragraph thing that says we deny everything, and the judge lets you get away with that. I doubt it, but maybe. But you got to know what the culture is in your jurisdiction. And this is true of everything that we talk about all semester long, and everything you'll talk about in every class in law school. How's it done in your jurisdiction? How's it done in your jurisdiction? What is the language that successful defense attorneys use in answering a complaint in your jurisdiction? Figure that out and use it. Okay? Yes?
How exactly exactly do you go about figuring that out?
You tell me.
I don't know.
This is going to be difficult for you, Miss Greenwell, because it involves contact with other human beings.
Oh, see,
And I know that you are a shrinking violet. Do not like to have contact with other human beings, but that's what it necessitates, right? You can do it via email if you don't feel like picking up the phone and talking to somebody. But if you really just can't find answers that have been filed in your jurisdiction, then reach out to other practitioners. You must reach out to other practitioners if you want to be a successful practitioner. Right? If you want to be a successful litigator or successful in anything that you do, you got to reach out to other people that are already doing it well and ask them. Yes?
Okay, so that's what I was going to say, but I was like, I don't think that's the right answer, so I didn't say that. But so.
Okay, I'll give you credit for the answer anyway.
Thank you, I appreciate that. Every little bit counts. I would
Does it though?
My next what?
Go on. What's your question? Go ahead.
Okay, so sorry. So I just didn't know that you could use other attorneys' stuff, I guess.
Oh, you're scared of the plagiarism thing, right?
I mean, maybe.
Yeah.
Like, you know.
You're not. That is not. You know, again, the world of plagiarism in the humanities and in academia overall is not the world of plagiarism in the practice of law, right? We expect you to copy good work product and use it, right? You don't copy paste somebody to the extent of using their client's names and not putting your own client's name in there, right? Which I've seen. Don't do that. But yeah, can you borrow from other practitioners? Can you look at their pleadings and then take the good stuff out of there and put it into your pleadings? Not only can you, you should, you must. You must. I would go so far as to say you must do that. There are limits to it. Like if you know, there's a case that I think if you guys were in my writing class, I might have showed you this case already. There's a case where this judge just absolutely shreds this poor attorney, sanctions this poor attorney for cutting and pasting like 50 pages out of a law review article and not citing it. You know, I mean, you can't. If you take it to extremes, there is a point beyond which you can sort of wade into the territory of plagiarism. But it's hard to do. I mean, if you're briefing a case, you should be looking at what other people briefed. Take the stuff out of it you like, plop it in your brief, rearrange it, change it to be about your scenario. Same goes with pleading, same goes with motions, same goes with anything, right? The judge is not going to sting you for plagiarism unless it's extreme. That's not a thing, right? That's not really a thing. Chad, you
I was just going to say, that also doesn't really just go to attorneys. Like you could, like the judge, like copying their either decision or past, if they just became a judge, their past practice, when they were practicing, their briefs. Is that something that you would say that's positive?
I don't understand.
So if the judge ruled in the favor of your position on the argument, that based on his ruling, you're constantly citing to his work, or his or her work.
Yeah. Well, then you're citing that judge, right? Then you want to cite that. If you have an opinion that's in your favor on a particular thing, then you want to cite that opinion in your favor. I'm not sure that I understand what your question is, though.
I'll use a comment, I guess.
Okay. Yeah. Okay. Where are we? Deny in part, right? We deny this part of the sentence, but not the other part of the sentence. Remember, we talked about in your complaint, you want to break that complaint into as small of pieces as you possibly can, right? So each allegation should be in a separate numbered paragraph. What you're supposed to do if you get a big hodgepodge sentence that has a bunch of different allegations in it as the defendant is to say, well, we deny the stuff that's false and we admit the stuff that's true. And in practice, that kind of gets muddled. And a lot of times what you see is just the defendant say, all right, well, that big long string of gobbledygook in paragraph 15. We just deny that. Or under 8b5, you can say, well, look, wait, I don't know, maybe. Defendant is without sufficient knowledge to admit or deny the allegations of plaintiff's numerical paragraph 5. Therefore, they are denied. That kind of language is why people will pay you $300 an hour. Okay? But that just basically says, we don't know. We don't know yet. And there's going to be things that you don't know yet at the stage of the answer. There's going to be things you don't know until you get way into discussion. You don't always have to answer literally everything, which we talked about. I mean, something that simply states, oh gosh, I don't know. So if in a plaintiff's complaint, for example, there's probably going to be a section, if it's a good complaint, there's going to be a section about the parties, and there will be a description of the plaintiff. Maybe one paragraph, maybe 2 paragraphs, that's just a description of the plaintiff. You don't have to answer that. You don't have to answer that, right? It doesn't require any sort of responsive language from you. You can just say, and you can track still paragraph by paragraph by paragraph, probably a good practice, is to make sure you hit something on paragraph 5. Like, look, Your Honor, we don't have to really say anything on this, but so here's the place marker that says we don't have to say anything. When in doubt, deny it. Right? Use your qualifying language. You can also, just like the plaintiff, use upon information and belief, such and such happened. You'll see that sometimes in the wild. But affirmative defenses is where we get into the real fun. Okay? And what are affirmative defenses? Well, let's just start by talking about that, make sure we understand what that is. What are affirmative defenses? When I say an affirmative defense, break that down for me and define it in layperson's terms.
So it's like saying you did it, but it's okay in this circumstance.
Yeah, kind of. It's kind of like, well, you know, maybe the stuff in the complaint is true, but we get to get away with it anyway, and here's why. Oftentimes, that's what an affirmative defense is. And as you've seen in your reading, some courts define it that way. So what are these things that are listed specifically in 8C? A lot. This is why we pay attention in our doctrinal classes too, right? Contracts and property, torts, all those wonderful classes. Not just lawyering skills, you got to pay attention in those classes too. Accord and satisfaction, what are we talking about with that? What is that? Do that in contracts? No? Yes, you did. You just don't remember these things. What's accord and satisfaction? Take a guess. Yeah?
They wanted it.
Yeah, basically. Yeah. Accord and satisfaction. Pays your bill. Right? This has been satisfied in some other way. We already reached an agreement on this thing. Right? Go back if you have some extra time this semester and crack that contracts textbook. Maybe over winter break. Okay. Arbitration and award? No. Chad, what's arbitration and award?
It's a agreement to go to a essentially it's a trial, but it's where both parties agree to go and have a neutral party decide it, and they will decide it pretty much like a judge. It'll be binding on the parties, and it has a very limited circumstance where it could be vacated in a court.
Yeah. Yeah, you're basically, with an arbitration, for those of you that don't know, it's basically like a mini trial in front of one person who's usually just a lawyer. And that is the kind of thing that you run into in lots of employment type situations, in consumer type litigation. If you have a credit card, you probably sign an arbitration clause for that credit card, which means that if you want to sue the credit card company, you don't get to go to court, you have to go in front of an arbitrator that the credit card company picks, and somehow you lose every time. Right? Assumption of risk, we know this from torts, right? If you don't, you're going to have to know it for the bar exam. Assumption of risk, we got it out. Contributory negligence, same thing. You guys are paying attention to torts, that's good. Duress, estoppel, failure of consideration, fraud, illegality, injury by fellow servants. Latches? What's latches? What's latches? I have litigated this, actually. It does come up every now and then. Really? Nobody? Yeah?
I think it's if you take too long.
You take too long. Undue delay, right? Undue delay. So, let's see, how would this come up? This is a terrible example, okay? But, say for example, the statute of limitations on something is 10 years, and I've waited 9 years and 364 days to file my complaint. Well, you might raise latches as an affirmative defense and say, hey, you slept on your rights for too long. Right? You waited too long to assert your right to this thing. That's the idea behind that. Anything else that we need to go over as far as these? Res judicata will cover pretty extensively towards the end of the semester, so I don't want to talk about that yet. That's collateral estoppel, that's issue preclusion, claim preclusion. That's what we're going to talk about. Statute of frauds. You guys covered statute of frauds, right? Statute of limitations, waiver. Any questions about those? You good with those? Do you have to plead all of these? You need to plead all of these in your answer? No. No, don't plead all of them in your answer. Although, what happens if you do? What happens if you stick all of those affirmative defenses from 8C and anything else you can think of into your answer? Let's talk about what could happen first. What could happen?
Isn't there some kind of sanction for filing frivolous claims?
Well, yeah, that's a possibility. What are you more likely to get from the other side, from the plaintiff? 12C, a motion for judgment on the pleadings?
Oh, 12B6.
12B6, no. That's a motion to dismiss. No, I don't think you'll get that. I don't think you'll get that. Go a little further down in Rule 12. Yeah, maybe you might get a motion to strike, something like that. I don't know. Maybe, right? Maybe the plaintiff will hit back if you put in all those affirmative defenses. In reality, you see all the affirmative defenses kind of get tossed in there in many answers anyway, right? Because defense attorneys are risk-averse creatures and they like to put everything down nice and neat just in case you might want to raise it later on down the line. Right? It's really hard to say at the pleading stage, they don't have grounds for that defense. They don't have grounds for that affirmative defense. Judge, you should get rid of that answer. You should strike portions of that answer. Because they don't have grounds for the defense. They'll say, yes, we do, we think, but we got to get into discovery and figure that out. Yeah.
Isn't it also bite the defendant? Like if they say, yeah, we did this, but we have this affirmative defense, and then the judge says, well, it wasn't illegal, or, well, there wasn't contributory negligence. Like, haven't you admitted to doing it, but what your defense wasn't true, and so now you're kind of stuck with that admission?
How do you handle it? Put your plaintiff's hat on for a second. How do you handle it? Defendant has put everything under the sun as far as affirmative defenses into their complaint. insufficient service of process, you're positive that they were properly served. You're positive. Statute of limitations, I know we served, I know we filed this within the statute of limitations. There's still 3 years left on the statute of limitations. How do you handle it? As plaintiff's counsel, how do you handle it? You know, motion to strike, we talked about that. Yeah.
The motion for definite statement, more definite statement.
No, I don't think so. I don't think that's the kind of thing that requires a more definite statement. Just because they've raised their affirmative defense and they're going to say, well, we're entitled to try to prove that affirmative defense later on. We don't have anything more definite to say about it. That's really more of a device that the defendant is going to use against the plaintiff for a poorly pleaded complaint. Neil?
Would Rule 11 deal with this? Because everything has to be in good faith. So if they're alleging things that are not in good faith, could you slap them with a sanction?
Making a Rule 11 motion is serious, right? Like, that's pretty serious business. So maybe that's appropriate, but I don't think I'd jump there. Yeah.
Motion for partial summary judgment.
I don't think I'd jump there either. Not yet. Not yet. I think that's a little less extreme than a Rule 11 motion, but I like the way you're thinking. Yeah.
Do you have to do anything yet if they have a burden of proof, if the defendant has to prove that?
No. No, you don't have to do anything, right? You could wait until trial and then see what the substance of their affirmative defenses is. However, what might be a better thing to do?
Right. Judgment on the pleadings are specific.
We're thinking too dispositively. Too early for that. You can't get a judgment on the pleadings. I mean, how are you going to get a judgment on the pleadings because their affirmative defenses are bad? They're not admitting the truth of what you said in your complaint with their affirmative defenses just because they suck at it. Yeah.
Reply to the answer.
Reply to the answer. Only if the, reply to the answer is only if the court orders it. I've never seen one. I've never seen one. One of those Rule 7. When I got a slide about it, we'll talk about it.
Could you amend the complaint and be more, trap them into not being able to use it?
No, think further down the line. There's an affirmative defense that they've raised. You know it's bullshit. How do you deal with it? Yeah?
Can you just move on to discovery?
Move on to discovery. Yeah, ask them about it in discovery. So craft your discovery, right? Craft parts of your discovery to respond to the answer, right? Insufficient service process, give you the factual basis upon which you are claiming service process was insufficient in this case, right? Get it discovered, yeah.
Could that also be used to, or could you also use the motion to compel for that, or is that what it's doing?
I don't think I would. I don't think I would. I've never seen a motion to compel used that way. I wouldn't take it completely off the table. Usually when we'll talk about it, usually when we're dealing with motions to compel, it's because you ask for something in discovery, the defendant hasn't turned it over, and you're like, give it here, right? Better to hash it out in discovery. And then if they come back with, well, we were just talking in a complaint, we're just saying stuff. Then you can go back, maybe move to strike the answer or one of the other remedies that we talked about. But then you've got solid evidence from the defendant in black and white that there was no basis for those affirmative defenses. Okay. King Vision pay-per-view. This is what we call a bench slap. Right? Who do you not want to be in King Vision pay-per-view? Did anybody read King Vision pay-per-view? Nearly certain that I assigned it. Who don't you want to be in that case? Yes. Yeah, you don't want to be the lawyers that filed that answer. You don't want to be the lawyers that filed that answer. What is it that they say that the court finds so objectionable in their answer? Yes?
They didn't admit or deny any allegations that demanded strict proof.
See it? Right there in the middle of page 464. Neither admit nor deny the allegations of said paragraph, whatever the paragraph is, but demand strict proof thereof. This is just something that they made up. The rules don't allow you to do that. There's no case that allows you to do that. They've never seen any other practitioner most likely do it. So this would be a cute way to answer the complaint. What if, instead of answering the substance of the allegations, we just put this for every single paragraph? So it might seem easy to answer a complaint. Just sit there and say, paragraph 1, no, paragraph 2, no, paragraph 3, no. But it's a little more involved than that. You don't want to be these guys. You don't want to be these guys. Okay. Problem 1 on page 465. Are you with me? Constant sues, Mo Surf, breach of contract. Defendant says, the documents speak for themselves. Is this proper under Rule 8? Who said yes? Okay. Who says no? Appreciate you being willing to. Let's break. I applaud you. Break. But no, in fact, if you put that in an answer, what's going to happen to you? Well, it depends, right? Know thy judge. Maybe the other side files a motion to strike, and maybe it gets granted. But the documents speak for themselves. It is not language that is contemplated by the rules, and therefore you cannot put that in there. That's what this court said in the Northern District of Illinois nearly 20 years ago. One of the only 3 alternatives that are permitted by Rule 8b is not the documents speak for themselves. The document speaks for itself is language that comes from what? Where does that come from? Where do you think they got that? Have you seen that before in some documents? Who's worked a lot on discovery? Yeah, maybe a little. You see that a lot in civil discovery responses. Objection, the documents speak for themselves. Without waiving the objection, plaintiff states that we still didn't do anything wrong. Okay. Stick to what the rules tell you can do. Red deer. Red deer. All right. First and foremost, what is the procedural posture of this case? In other words, what is the court deciding on? Normally, when we read these cases, it's on a motion for summary judgment or a motion to dismiss, right, from the trial courts. Or at the appellate courts, it's whether or not we're going to affirm or reverse the decision of the trial court. But where are we here? What is the procedural device that brought this case, or that created this opinion, that brought this opinion into being? The judge is ruling on what?
Motion in limine.
Motion in limine, yeah. Motion in limine. And it may have been styled a motion to exclude, motion in limine to exclude, something like that. But it's a motion in limine. What's a motion in limine?
Objections to evidence.
Right, you know this, right? Motion. What are we trying to do with a motion in limine? The most citrusy of motions. What is it? What does it do? Yeah?
Evidence out of trial.
Yeah, it has to do with something at trial, something that's going to be heard at trial. Right? Motion in limine is the jury should not hear this evidence, or let's get this ironed out before we actually put the jury in the box. Okay? So it's in anticipation of trial. And what is the motion in limine that was made by the plaintiff prompting this opinion? The motion to exclude, maybe, but motion to exclude what? What are they? Tell me in plain English. What is it that they're trying to do? What is the plaintiff trying to do? Kelsey.
They don't have their employment history, like when they got fired, be introduced to trial.
Kind of. Yeah.
Evidence that was gathered after the discharge or the termination. So it
Yes.
wasn't
Evidence of what?
why they fired her.
The after acquired evidence rule that they talked about.
Not to hire her.
How?
Not to hire her.
What is the after acquired evidence bit that they're talking about here? What is that? Who can explain that to me? What's after acquired evidence in an employment context? Did you get that in this case, or was it just like, yeah, I'm just going to gloss right over that and get this reading done? Go ahead.
Wasn't it like they chose not to hire her for certain reasons, and then after that happened, they found other evidence of why not to hire her? So she was trying to say they can't bring in that evidence because that can determine.
Yes, that's right.
Wasn't it?
Yeah, that's right. The way this comes up is most often not in a failure to hire context, because failure to hire cases are kind of rare anyway. But usually the way this comes up is plaintiff gets fired, claims race discrimination or retaliation or some other illegal reason for the termination, right? And defendant, using the after acquired evidence rule, can in most jurisdictions then say, even if we fired this person for a discriminatory reason, even if this termination was illegal, if we had known that he had been convicted of jaywalking in 1995, we never would have hired him in the first place, and therefore the whole case has got to go. Again, you're not entitled to any damages. That's the after acquired evidence rule. You lied on your employment application and said that you never had any convictions. But in fact, here's this burglary conviction from 3 years ago. We just didn't run a criminal background check on you and hired you anyway. But if we'd have known about that burglary conviction, definitely wouldn't have hired you. Okay? That's an affirmative defense. What the court says is that's an affirmative defense. Right? What the court says is that's an affirmative defense that has to show up in the pleadings. Why? How do they reach that decision? Everybody get what after acquired evidence is, right? You got that, right? Got to show up in the pleadings. Why? Yeah.
Will they come up with like 3-prong kind of test or something that they do to see if it meets these 3 criteria? So I don't know if you want me to read the criteria.
Well, if you want to just sum it up, you don't have to read it.
Basically that if it doesn't controvert the claim, if it avoids the claim, then they say that it's affirmative, and it has to be pleaded to prevent surprising the plaintiff with evidence that they weren't aware of, and giving them a chance to like formulate their response.
Yeah, this court gives a 3-part test that essentially boils down to, does the defendant have the burden of proof And is this something that would totally short circuit the plaintiff's complaint, even if everything was perfectly true in it? Right? Is this something that would kill off the plaintiff's case? I should say case, not complaint, because they're already getting ready to go to trial. And they say that after acquired evidence fits the bill. Because again, even assuming the discriminatory hiring, non-hiring in this case, took place, say, well, she didn't disclose this other fact about her background, so there's no way we would have hired her anyway. Make sense? Oh, and what does the court do? What's the remedy? And you get where we are. Defendant says, we get to use after acquired evidence in trial. Plaintiff says, no, you don't. Court says, yes, you do. You get to use it. But also says, it's an affirmative defense that should have showed up in your pleadings. What's the remedy? What happens? How do they reach that conclusion? You know?
The motion is denied.
What?
The motion's denied.
The motion is denied. Well, actually, the motion.
To suppress the employment.
They say, yeah, and this is what I'm getting at. The court says it's an affirmative defense. The court agrees with the plaintiff. Right? That's the outcome here. The court agrees with the plaintiff and says, yeah, that should have gone in your answer. You have to affirmatively plead that. So why does the defendant still get to put the evidence in?
Yeah, I was gonna say they have to go back
An amendment, yeah. Yeah, the court allows an amendment to the answer. Right? Isn't this fun? Isn't this fun? So, when I say there's very little opportunity for you to really destroy your case in just the answer alone, that's the kind of thing that I'm talking about. There's very little that goes on in civil litigation that you can't, you're going to blow your statute of limitations, and that's really bad as a plaintiff. But in most cases, anything that you've screwed up, you can kind of go back and unscrew. Right? Rules are pretty generous about that stuff. Now, will your individual judge be generous about it? I don't know. Sometimes you have a responsive pleading that is called a response and not an answer. That usually happens when the initial pleading is called a petition. Okay. Petition for habeas corpus, response to petition for habeas corpus. Petition for bankruptcy, response to petition. Same stuff. Answer doesn't matter a whole lot unless you totally blow it. Answer is terrible. Plaintiff can move to strike. Not such a great idea for the plaintiff. Just creates a whole lot more work for everybody, and you can go back and amend your answer anyway. As a plaintiff, again, what you want to do is get them hung up on the stuff that's wrong in their answer in the discovery phase. Hang it there, okay? Look at Rule 9C to make sure that you don't need to be more specific in the way you plead your defenses. Number 9C lays out some stuff that you have to plead with particularity. That applies to your answer too. In this 787, I had somebody ask me about this last week. I've never seen one filed. Reply to an answer. I think what the language of the rule is, if the court orders a reply to an answer, and you file a reply to the answer. I've never seen it, ever. Maybe very common in some jurisdictions, but I've never seen it. So, and I only point that out to, if you're sort of tracking the roadmap of where we are in our fake litigation in your head, like, don't think that the natural next step is going to be the reply to the answer. not. I've never seen it. All right. The example that you've got in your book on 465 is actually a pretty good one. Simple, right? It's exactly what you would expect. And the book example is about as simple as you'll see. Right? The heading, or the answer, we state 1, 2, 3, 4, 5, right? So you have an admission for paragraphs 1, 2, 4, 6, 10, and 21. You often see those all lumped together in one paragraph in the defendant's answer, yeah. Denial, outright denial of the entirety of paragraphs 14, 15, 17, 18, 19, 22. What this example doesn't do, that you will often see done, is to carve out a whole section for affirmative defenses. Look at this real answer. This is divided up. This is not the defendant's divisions, right? This is the defendant tracking what the plaintiff already filed. So parties, we're going to answer every single paragraph that plaintiff filed for parties. Jurisdiction and venue, same thing. Facts, and for every paragraph. Also, there's this reincorporation language too, which might be a little bit of overkill, but not bad. Not bad to have. But, yes, Brent.
Okay, so in an answer, is it necessary to have a prayer for relief, and what kind of relief can you receive in an answer?
No, we don't need one.
Okay.
No, we don't need one. Rules don't require you to do that. Rules
Okay.
just require you to answer the allegations against the defendant. Yes?
Can you go back up? Is it, what do they say, can you keep going? What do they say for jurisdiction and venue in the answer? What's?
In this one, they say, defendants, and this is, I mean, this is just the defendant being very fastidious and answering every single paragraph. Not a bad idea. Again, defendants lack sufficient information to form a belief as to the truth of the allegation. See, I told you, magic language. We don't know, right, regarding plaintiff's basis for seeking relief. We neither admit nor deny said allegations, but demand strict proof thereof. Okay. Defendants deny that Section 504 of the Rehabilitation Act is applicable. Okay. So basically, they're saying the basis. So the plaintiff has said that the basis of the suit is federal question, and this is the defendant's sly way of saying, well, we don't know if there's a federal question here. We're not going to admit to jurisdiction. Is that maybe overly cautious? Maybe. Maybe. But unless you know you've got a judge that is really going to stick it to you for putting language in there like that, it's probably better to be overly cautious. Facts. They track causes of action in this one, and you'll see other complaints that don't. The example in your book doesn't. But all these headings, these are the plaintiff's headings, and the responses there too. Negligence, wrongful death. And then a whole separate section, and this is what to pay attention to. The whole separate section for affirmative defenses. Fails to state a cause of action, barred, statutory bar, ensure qualified immunity is in there. Yeah, qualified immunity. Okay. That's a fun one that you'll learn about when you take my civil rights class. Signature line, certificate of service. Okay? Easy, right? Easy. Can you do it? 20 minutes? Sure, why not? You can at least get a good running start, right? Oh, one thing I want to tell you here, maybe you'll have only 15 minutes. Counterclaims, right? Look at Rule 13A, I didn't assign it to you, but make a little note to yourself to look at Rule 13A, because did you talk about compulsory counterclaims last semester? Not a thing, or was it? Sometimes, if you have a claim to bring against the plaintiff, right? Plaintiff files against the defendant. The defendant's been sitting on a lawsuit thinking about it for a while, and gosh, maybe we should sue that plaintiff. And then gets hit with a lawsuit from the plaintiff. If it arises out of the same transaction or occurrence, the same stuff that gave rise to the plaintiff's complaint, then you may have to be required to assert a counterclaim against that plaintiff or lose it forever. I don't want to get way too deep in that because it doesn't come up a whole lot, but it's an important thing to know about. Questions about that? Okay, getting your groups. Serve your complaint on a different group this time than you did for your motion to dismiss, and then quickly answer the complaint that you received. Questions? Got it? Easy, right? Simple. Track it paragraph for paragraph for paragraph. I want to see some affirmative defenses.
So, complaint nature.